Hello, everyone, and welcome to Uncivil Law. And for today's case, we bring ourselves to the attention of the U.S. Supreme Court, which just issued a decision in a pending case without oral argument, which is pretty rare. I'm not sure the last time this happened. So we sometimes see cases on the so-called shadow docket. Those relate to injunctions. But this was pending on the merits docket. And the U.S. Supreme Court just issued a decision with just immediately, without oral argument. So it was pending consideration, like listed for, potential picking up by the court. The court listed it over and over again as just like, I'm considering this for a potential cert. And then they're like, we have a decision. We just have a decision. Oh, okay. So that's something that just happened. All right. We just have a decision. No oral argument on the merits case. So the Supreme Court apparently thought this was so clear and so obvious. They're like, we don't need no stinking oral argument. We're literally just going to do it on paperwork. Fine. That's what we're doing. So we bring ourselves to the attention of Andrew versus White, Warden, in a habeas petition. Per curam, issued in the name of the court. In a 7-2, incidentally, by the way, per curam doesn't necessarily mean unanimous, and it wasn't unanimous here. Okay, anyways, an Oklahoma jury convicted Brenda Andrew of murdering her husband, Rob Andrew, and sentenced her to death. It's a death penalty case. Those are always exciting. The state spent significant time at trial introducing evidence about Andrew's sex life and about her failings as a mother and wife, much of which was later conceded irrelevant. Okay, that's super exciting. We've got a bunch of information that is completely irrelevant regarding the sex life of this woman introduced in this death penalty murder trial. Fantastic. In the federal habeas petition, Andrew argued this evidence was so prejudicial as to violate due process. So we sort of have this idea in the federal rules of evidence. We talk about this as 403 in the federal rules of procedure, right? We have this idea that even if information is somehow relevant anyway, we do have this escape valve of rule 403, right? Even if the information is otherwise relevant, the court can exclude it for, among other reasons, if it's substantially more prejudicial than probative. Okay, and that's an idea that we have in the federal rules of procedure. But this is a state level case. This is a state level case, and states do have that equivalent as well. Most states do. But then the question becomes, okay, so the state didn't do that. The state didn't do that. Is that a federal constitutional problem? Because that's the only reason the federal courts can get involved, is if there's a federal constitutional problem. So this is a state level proceeding, and states normally are, of course, masters of their own evidentiary rules. Because, what's the alternative? The states are master of their own evidentiary rules. So the state's like, okay, we think that this evidence is relevant, or maybe not, depending on which stage of the proceedings we're at, but we don't think it was a problem big enough for us to fix, basically, right? This was bad, they shouldn't have done it, but it's not big enough a problem for us to fix as a matter of state level law. So the only way the feds can get involved is if it's a constitutional violation, namely due process in this case. So was the information so vile, so prejudicial, that its introduction violated fundamental promises of due process? That's a lot, man, right? That's a lot, but that's what they're talking about, okay? So the Andrew, the woman, argued the evidence was so prejudicial as to violate due process. The Court of Appeals rejected the claim because it thought no holding of this court, that'd be the U.S. Supreme Court, established a general rule that erroneous admission of prejudicial evidence could violate due process. That was wrong. That was wrong. Oh, okay. So no, it's possible, says the U.S. Supreme Court. It's possible. It is possible that you introduced evidence that was so vile, so repugnant, so prejudicial, that it violated the person's fundamental due process rights. That's how bad you fuck this up. That's how bad you fuck this up. And the U.S. Supreme Court is like, yes, that is a thing that could occur. So Court of Appeals that said, there's no holding of this court that says that. The Supreme Court's like, yes, there is now. So yes, you can fuck it up that hard. That is a thing that can happen. And then the Supreme Court says, we already have said this, which is one of the reasons they did it like basically without an oral argument. They're like, not only is it the law, it's been the law and you just can't read. So we're going to help clarify that for you. By the time of Andrew's trial, this court had made clear that when evidence is introduced that is so unduly prejudicial, it renders the trial fundamentally unfair, the due process clause of the 14th Amendment provides a mechanism. We said that in 1991, Court of Appeals. It wasn't like it's a recent decision. Court of Appeals. We said it 34 years ago. Court of Appeals. 34 years ago, we're like, you know what? It is possible, in principle, for there to be evidence that's so prejudicial that it violates a person's fundamental due process rights. It might take a lot. It might not be easy to prove. It might be a somewhat rare case, but it is possible. It is a thing that's possible. And the Court of Appeals 34 years later is like, we don't know of any case that says that. And the Supreme Court is like, you can't fucking read. Try harder. Try harder. We said it 34 years ago, you idiot. All right, great. Moving on. Let's learn a little bit more about the facts of this particular case. On November 20th of 2021, Rob Andrew was fatally shot in his garage. Brenda Andrew, who herself had been shot in the arm during the incident, told the police that two armed assailants had committed the shooting. Andrew, that would be the woman, further explained that she had been separated from her husband and was now dating James Pavitt. But she and Rob continued to see each other as they had two children together. How nice for them. Pavitt and Andrew traveled to Mexico together after Rob Andrew's death and soon became suspects in the murder. That is a little suspicious, right? It's a little suspicious, so, right? It's like, oh, yeah, my husband was shot. And I was shot too by these two assailants. And now I'm going with my lover to Mexico. It's like, yeah, okay, maybe she did it. Maybe she did it. This is a little suspicious. Okay, moving on. Eventually, Pavitt, the lover, confessed to committing the shooting with a friend. The lover did it. Pavitt denied that Andrew had been involved. However, the state's like, we don't believe that bullshit. The state therefore charged both Pavitt and Andrew with capital murder, and the jury convicted Pavitt and sentenced him to death. So Pavitt said, I did the murder, and the state's like, okay, cool. How about capital punishment? And then, you know, Pavitt's like, okay, the wife wasn't involved, and the state's like, we don't believe you. We think she was involved. We're charging her with capital murder too. Pavitt is convicted and sentenced to death. So there's a lover gonna die. How about Andrew? What is her fate? As to Andrew, at Andrew's trial, the prosecution sought to prove that Andrew had conspired with Pavitt. Well, that would do it, right? That would do it. It was a conspiracy to commit murder. Fantastic. And insurance agents to murder her husband, incidentally, and also obtain proceeds of the life insurance. So we did it for love and money. How nice. Among other things, the prosecution elicited testimony about Andrew's sexual partners reaching back 2 decades. Uh-oh. About the outfits she wore to dinner or during grocery runs. Uh-oh. About the underwear she packed for vacation. Uh-oh. And how often she had sex in her car. Uh-oh. Okay. That seems problematic. We think that Andrew and Pavitt are in a conspiracy to off the husband for love and or money. That is their motive. Okay? We think that Andrew, the wife, did it for love of the new lover and money in a classic tale. Okay? And to prove that she did the murder, we'd like to talk about how often she had sex in her car. Uh-oh. Maybe keep your eye on the ball, prosecution team. That would have been more helpful. Okay? at least two of the prosecution's guilt phase witnesses, so liability, where, of course, the rules of evidence are more constricted than during sentencing, right? This is the did she do it phase, where the rules of evidence are more restrictive. So in the did she do it phase, the prosecution brought two witnesses to the stand to testify about Andrews, the wife's, provocative clothing. Didn't she wear slutty outfits sometimes? Holy shit. And others were asked to comment about whether a good mother would dress or behave the way Andrew had. Guys, prosecution, this is a Wendy's, as they say. This is a Wendy's. Maybe in the conspiracy murder trial, we should be focusing more on, the conspiracy and less about whether or not she dresses in a way that's consistent with being a good mother or not. It feels a little off point, prosecution team. It's a little off point. Maybe we shouldn't be talking about that at the capital murder trial. Great, moving on. In its closing statements, the prosecution has more things it's like to share. In its closing statement, the prosecution again invoked these themes, including in the closing arguments by displaying Andrews, the wife's, thong underwear to the jury. Ladies and gentlemen of the jury, look at this thong underwear. We are literally doing this. Holy shit. By reminding the jury of Andrew's alleged affairs during college. What does that have to do with the price of tea in China? Holy shit. And by emphasizing that Andrew had sex on her husband over and over and over while keeping her boyfriend on the side. Great. At both the guilt and sentencing phases, prosecution contrasted Andrew with the victim, who they asserted had been committed to God. I'm not saying that she didn't do the murder. I'm saying that she dresses like a whore is not really great evidence for she did the murder. She dresses like a whore and she sleeps around and she cheats on her husband and past boyfriends and stuff. She's a slut and she dresses like it, therefore find her guilty of murder is not exactly the most compelling argument I've ever heard of in my life. Holy shit. But that's what the prosecution wants to do, again, during this capital murder trial. We want to kill her. Let's talk about whether or not she slept with people in the car and stuff. Holy God. The jury convicted Andrew and sentenced her to death. Fantastic. On appeal, Andrew argued that the introduction of the irrelevant evidence, including evidence that she had extramarital sexual affairs with two other men, and that she had come onto another witness's son, and she dressed provocatively at a restaurant, violated Oklahoma law as well as the federal due process clause. It does feel a little off point. Feels a little off point, man. Oklahoma. The Oklahoma Court of Criminal Appeals held that the admission of the evidence about Andrew's extramarital affairs had been proper. Oh, okay. That's genius. The Oklahoma Court of Appeals is like, we see no problem with this. The Oklahoma Court of Appeals is like, yeah, we see, this seems perfectly fine to us. We see no problem with, the slut shaming argument during the capital murder trial. This seems perfectly fine. We see no issues. Totally fine with us, says the Court of Appeals of Oklahoma. Holy God. The Oklahoma Court of Criminal Appeals. Wait a second. The Oklahoma Court of Criminal Appeals. Is that the Supreme Court? Let me check. It sure is. I had to double check. Holy shit. I'm sorry. When I said Court of Appeals, I'm sorry, because Oklahoma is like Texas. For some reason, I'm not really sure why either Texas or Oklahoma did this in its infinite wisdom. But both Texas and Oklahoma have two Supreme Courts. We weren't happy with just one. We weren't happy with just one. We've got two Supreme Courts. We're very excited about it. Oklahoma also has two Supreme Courts, and they're very excited about it. The Oklahoma Supreme Court and the Texas Supreme Court deal with civil law. The Oklahoma Court of Criminal Appeals and the Texas Court of Criminal Appeals deal with criminal law. But they are the Supreme Court with respect to criminal law. So it wasn't just the Court of Appeals. It was the Supreme Court of Oklahoma. The highest court of Oklahoma is like, this is totally fine. We see no problem with this. This is totally great. This is just A-okay, man. Holy shit, man. Holy shit. Oh, man. Okay, so the Oklahoma Supreme Court held this is totally fine because it showed that her co-defendant was just the last in a long line of men she seduced. I'm not sure that's a reason it's okay so much as a reason it's blatantly not okay, but okay, you know, you do you, I guess. The Oklahoma Supreme Court struggled, however, to find any relevance other than to show character, which, you know, in the middle of the liability phase is a bit of a problem, for the remaining challenged evidence. By now, the state agreed most of the evidence was irrelevant to any issue. The Oklahoma Supreme Court nonetheless denied relief on the ground that trial's errors had been harmless. The Oklahoma Supreme Court would like to let you know that accusing women of being slutty in order to convict them of being murderers and sentencing them to death is just A-okay. And if it was bad, it wasn't that much of bad. So let that death penalty continue, man. Holy shit. Holy shit, man. Judge Johnson dissented in part. In his view, the egregious pattern of introducing evidence that had no purpose other than to hammer home that Brenda Andrew is a bad wife, bad mother, and bad woman trivialized the value of her life in the minds of the jury. He therefore would have vacated the sentence. Judge Chappell dissented separately, indicating he would have reversed the conviction and remanded. All right, so having exhausted all of our state level appeals, and the state's like, this is totally fine, we see no problem, let's now try a collateral attack, okay? We're now gonna try a collateral attack. So instead of Andrew versus Oklahoma, this now becomes Andrew versus White, the warden, right? That's the nature of the collateral attack. So we're now going to sue the warden and say, you can't keep holding me, okay, on a habeas petition. All right, so Andrew versus Oklahoma becomes Andrew versus White, the warden. In federal court, Andrew reiterated her claim that the omission of evidence rendered the guilt and penalty phase of her trial fundamentally unfair in violation of due process. The district court denied relief. The district court says this is totally fine. No problem. Please enjoy your death penalty. A divided 10th Circuit affirmed. The 10th Circuit Court of Appeals is like, we're good. Please enjoy your death penalty. Holy shit. A divided 10th Circuit affirmed because it held Andrew had failed to cite clearly established federal law governing her claim. The majority acknowledged that Andrew had cited Payne, in which this court said the due process clause provided a mechanism for relief when the introduction of unduly prejudicial evidence renders a trial fundamentally unfair. However, the majority, apparently not being able to read, held that this had been a pronouncement, not a holding of the court. What the fuck? So, okay. The Court of Appeals for the 10th Circuit looked at this statement and they said, this isn't a holding, it's a pronouncement. It's not a holding, it's a pronouncement. First of all, what's the difference? Second of all, pronouncements don't count. It's just a pronouncement. What does that mean? I don't know. But it didn't count. It didn't count for some reason. The U.S. Supreme Court saying exactly the thing. The U.S. Supreme Court saying literally exactly the thing doesn't count. Neat. It therefore concluded Andrew had failed to identify clearly established federal law governing your claim as required by the Anti-Terrorism and Effective Death Penalty Act. As a result, the majority declined to consider whether the Supreme Court of Oklahoma unreasonably applied Payne, that is, whether a fair-minded jurist could hold the admission of irrelevant evidence about Andrew's demeanor as a woman was not so prejudicial as to deprive her of a fundamentally fair trial. Saying instead, quote, the absence of clearly established federal law is dispositive. What the hell are you talking about? The Supreme Court used like literally those words. In dissent, Judge Barrett condemned the state's focus from start to finish on Miss Andrew's sex life, a move he argued portrayed Miss Andrew as a scarlet woman, a modern Jezebel, sparking distrust based on loose morals, plucking away any realistic chance the jury would seriously consider her version of events. Judge Barrett, therefore, would have held the combination of evidentiary errors deprived Miss Andrew of a fundamentally fair trial. Okay. All right. So the question presented apparently was, okay, when the U.S. Supreme Court in 1991 said, hey, prejudicial evidence can be a due process violation, did they mean it? $20 from Drake says, unrelated, but do you plan to cover Moore versus Lions credit union ruling? Maybe. I don't know. I'll get back to you. At the moment, we're trying to determine whether the Supreme Court staying stuff counts or not. That's apparently the legal question I have to resolve. That's exciting. That's the legal question I have to resolve. When the United States Supreme Court literally says, asking a question that is prejudicial can be a due process violation, does that mean that asking a question that's prejudicial can be a due process violation? That's apparently the question I have to answer right now. Moving on. A federal court may grant habeas relief as to claim adjudication of the merits in state court only if the state court relied on unreasonable determination of the facts or unreasonably applied clearly established federal laws determined by this court. To show the state court unreasonably applied clearly established federal law, a petitioner must show the court unreasonably applied the holdings as opposed to dicta of the court. An unreasonable application, in turn, is one in which no fair-minded jurist would disagree. When this court relies on a legal rule of principle or principle to decide a case, the principle is a holding. I didn't know we needed to clarify that. I'm super excited. There is a U.S. Supreme Court case that tells me that. Apparently, Locker versus Andrade tells me that. I was unaware we needed a Supreme Court case for that proposition, but apparently we do. Apparently, we need a Supreme Court proposition for the proposition, or a Supreme Court case for the proposition that if the Supreme Court relies on it in reaching the decision, it like counts and stuff. Great. Moving on. In Payne, this court considered whether to overrule a set of prior cases that had categorically barred the introduction of victim impact statement during sentencing phase of a capital trial. So at some point in the federal law, at least, there had been some cases that said you can't have victim impact statements during sentencing. Okay. I mean, that was just like the rule. You can't have victim impact statements at sentencing. I mean, that was the rule. Okay. So in Payne, the Supreme Court's like, maybe that's a stupid rule. Maybe we should have a different rule. But that was the rule. Okay, fine. The court noted that in many circumstances, victim impact evidence serves entirely legitimate purposes, even though in others it could be prejudicial. It then concluded the categorical bar was not necessary to protect against the risk of prejudicial testimony because the Due Process Clause of the 14th Amendment provides a relief against introduction of evidence that's so unduly prejudicial it renders the trial fundamentally unfair, which, okay. So we're going from a rule, you can't do this, to more of a discretionary system. So the old exciting rule was no victim impact statements at sentencing. You just can't do it. No victim impact statements at sentencing, go away. The new exciting rule is, okay, that old exciting rule was dumb. The new exciting rule is, yes, you can do it, but also the court can exclude it if it would be too prejudicial. And then we're just back to Rule 403. Right? Which we all know and love, right? Even if relevant, even if otherwise permissible, even if otherwise acceptable, 403 is our safety valve. 403 says that even if it would otherwise be allowable, the court can say no for, among other reasons, if it's so prejudicial as to overwhelm its probative value. And Rule 403 can also be used to exclude a victim impact statement. Wow. That's amazing. Wow, you mean like a victim impact statement could just be treated like other evidence, and the rule that says if it's too prejudicial, you shouldn't allow it, and you could apply that rule to the victim impact statement too? Holy shit. Wow, that's amazing. We can just treat it like evidence and like apply normal rules to it. Wow, that sounds super exciting. Thanks for clarifying that. Holy shit. All right. So you can have it, you can do it unless it's too bad. Unless it's too horrible, then you can still exclude it. Fine. In light of that protection, the court held it could permit victim impacts evidence where appropriate without risking undue prejudice. In other words, the court removed one protection for the capital defendant, which was the per se, which is to say absolute bar on victim impact statements, in part because another protection, due process clause, remained available against evidence that's so unduly prejudicial it renders the trial fundamentally unfair. Cool. The legal principle on which Andrew relies, that due process clause can, in certain cases, protect against the introduction of unduly prejudicial evidence at the criminal trial, is therefore indispensable to the ruling in Payne. Yeah, I mean, the whole reason we allowed the victim impact statements is because we're like, oh, there's always this escape valve called due process, right? The reason we said we can allow the victim impact statements is because we have the escape valve of due process. Due process can be used to exclude the really bad evidence. And then the Court of Appeals was like, duh, I don't know, man. I don't know if the Supreme Court has ever said that due process can be used to exclude evidence. I don't know if they've ever said that before. Dur, 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 dur. Holy shit. Yeah, holy shit. That means it was a holding of this court for the purposes of the Effective Death Penalty Act. Importantly, Payne did not invent due process protections against unduly prejudicial evidence. Rule 403 has been around for a while. The court has several times before held that a prosecution's prejudicial or misleading statements would violate due process if they render a trial or capital sentencing fundamentally unfair. Well, holy shit, that's just a deep revelation. And again, we had to apparently say it 3 separate times. Because I guess just once wasn't enough. Okay. Is it possible that prejudicial or misleading evidence could be like a bad thing that could like violate due process? Is that possible? Is it possible that the evidence could be so prejudicial, so inflammatory, so out of pocket that, right, it would be like a constitutional problem? And apparently the US Supreme Court had to say yes 3 times and then said it again in Payne and is saying it again now. So 5 times. 5 times now the Supreme Court has said it. Maybe one of them will count someday. Maybe one of them will count someday. Who can say? Prejudicial evidence can be prejudicial, yo. Payne thus broke little new ground. By the time of the OCCA's decision in this case, it was clear the introduction of unduly prejudicial evidence could, in certain cases, violate due process. Not incidentally that it does, just that it's possible. It's possible. It's at least possible. Jesus Christ. The Court of Appeals nonetheless held Payne, this should be good. This should be good. The Court of Appeals nonetheless held that Payne merely established that the Eighth Amendment did not erect a per se bar to the introduction of victim impact statements in capital cases. Well, okay. As just explained, however, Payne expressly relied upon the availability of relief under the Due Process Clause. So, you know what the Supreme Court said? The Supreme Court said it's not an Eighth Amendment problem, but it might be a Fifth Amendment problem. I mean, there are like more than one amendment. Court of Appeals. So it's not an Eighth Amendment problem, but it might be a Fifth Amendment problem. Due process. Durr. Durr. This court has accordingly applied Payne's framework to a claim much like Andrews that the introduction of prejudicial evidence at sentencing violated due process. Oh my God, we said it a 6th time. How many times do we have to say it? Holy shit. Moreover, the court relied on Payne in the same way Andrews sought to rely on it here, for the purpose that the Due Process Clause wards off the introduction of prejudicial evidence that would render the trial fundamentally unfair. Kansas v. Carr, a 7th time. This court has also relied on the underlying fundamental fairness in a jury impact. See Randu versus Louisiana, an 8th time. Skilling versus United States, a 9th time. Ugh. To the extent the Court of Appeals thought it constrained by the ADEPA to limit Payne to its facts, it was mistaken. General legal principles can constitute clearly established law for the purposes of the ADPA, so long as they're holdings of the court. For example, the Eighth Amendment principle that a sentence may not be grossly disproportionate to the offense is clearly established, even though it relies out of the thicket of Eighth Amendment jurisprudence and lacks precise contours. In other words, a cruel and unusual penalty might be cruel and unusual. Right? That's what that says. So the Supreme Court has opined without particular clarity on this point that it's at least possible that a sentence for a crime could be so harsh that it would be unfair under the Eighth Amendment. In other words, it's possible that a criminal penalty could, be cruel and unusual by the fact of it being cruel and unusual. So, if you pass a law that says, anyone who does speeding goes to jail for the rest of their life, it might be a bit much. So that might be an Eighth Amendment problem because, cruel and can you read the words? Do you understand what that means? Holy shit. To the extent that Court of Appeals thought itself constrained, it was mistaken. Although this court has not previously relied on Payne, to invalidate a conviction for improperly admitted prejudicial evidence, moreover, certain principles are fundamental enough that when new factual premeditations arise, they necessarily apply the early ruling well beyond doubt. In other words, I know that there was a change of facts and all, but you have like taken this idea of clearly established to absurd levels. Right? This is basically what the Court of Appeals below did, basically, is qualified immunity on steroids. That's basically what they did, right? It's like we need a violation of the Constitution, and it has to be clearly established. So basically, they're like, well, it wasn't clearly established enough. And the U.S. Supreme Court's like, look, assholes, okay? Look, assholes, certain principles are fundamental. So even though there are some new factual permutations, they're still fundamental and they still apply, you dipshit. The Court of Appeals thus erred by refusing to even consider whether the OCCA, again, the Supreme Court of Oklahoma, unreasonably applied established due process to Andrew's case. The dissent maintains that a reasonable jurist could agree with the 10th Circuit's understanding of our precedent. That assertion conflates the deference federal habeas courts must extend to states' application of this court's precedent with the federal court's independent obligation to first identify the relevant, clearly established federal law. Federal courts get to determine what federal law is. Film at 11. A legal principle is clearly established for the purposes of the Effective Death Penalty Act if it is a holding of this court. This court has no occasion to defer to other federal courts' erroneous interpretations of its own precedent. That's a sentence I didn't know I needed in my life. That is a sentence I did not know I needed in my life. Okay? This court has no occasion to defer to other federal courts' erroneous interpretation. Yeah, that would be good. The Supreme Court says it doesn't have to defer to the lower courts screwing up the Supreme Court decision. Did you need a case that said that? Did you need a case that said that? Did you need a case that says the Supreme Court is under no obligation to defer to the lower court's misinterpretation of the Supreme Court? If you needed a Supreme Court case to tell you that, congratulations, you have one. The Supreme Court is, in fact, not bound by the lower courts. I'm amazing. Nor is such double deference necessary to prevent expansion of federal habeas relief to those who rely on debatable interpretations or extensions of our holdings. Andrews does not rely on an interpretation or extension of this court's case, but on a principle this court itself has relied on over the course of decades. Because the 10th Circuit nonetheless held that no reliance clearly established law existed, a ruling that this court reviews de novo, oh my God, the Supreme Court is reviewing a legal question de novo? So wait a second, let me make sure I understand this. Bold proposition. All right, let me make sure I understand this correctly. Are you telling me the U.S. Supreme Court is trying to determine the law and is doing it de novo? Wow. What a bold and exciting decision this is. What a bold and exciting decision. Legal questions are given no deference to lower courts. Wow. I'm learning so many things. On remand, the Court of Appeals should conduct that inquiry in the first instance. Specifically, the question now is whether the fair-minded jurist reviewing this record could disagree with Andrews that the trial court's mistaken admission of relevance evidence was so unduly prejudicial as to render her trial fundamentally unfair. What is the probability that this winds up back at the Supreme Court someday? Probably pretty good. Right? It's like we literally just took the 10th Circuit out behind the woodshed and beat them to death. And now that we're like, hey, now that we've beat you to death, do you think you can apply it now? Do you think you can apply our decision now? What do we think? What do we think, chat? What is the probability the 10th Circuit can apply this decision now? What is the probability we're going to be back at the Supreme Court someday on exactly this case? I'm feeling like we might be back, guys. The Court of Appeals must ask that question separately for the guilt and sentencing phase. As to each phase, it must consider the relevance of the disputed evidence to charges or sentencing factors, the degree of prejudice Andrews suffered from its introduction, and whether the trial court provided any mitigating instructions. The ultimate question is whether a fair-minded jurist could disagree the evidence so infected the trial with unfairness as to render the resulting conviction or sentence a denial of due process. At the time of the Supreme Court of Oklahoma's decision, clearly established law provided that the due process clause forbids the introduction of evidence so unduly prejudiced as to render a trial fundamentally unfair. Holy shit. I didn't know that we needed to clarify this, but once again, here is your new exciting legal holding. Or is it a legal holding? Maybe it's just a pronouncement. I'm not sure. But either way, here is your new statement of law. You ready for this new exciting statement of law? You ready to have your mind blown? Okay, here is your mind-blowing new law, people. The due process clause forbids the introduction of evidence so unduly prejudicial as to render a criminal trial fundamentally unfair. Mind blown. This court accordingly grants the petition for certiorari and the motion for leave to proceed in forum pauperis, vacates the judgment, and remands this case for further proceedings. So, as I stated before, this was done without oral argument, which is pretty rare, which shows you how pissed the Supreme Court is. I'm trying to remember the last time the Supreme Court did a merits decision without oral argument. It's been a while. It's been a while. But they did it. They did a merits decision on the paperwork. That's how pissed they are. So, yes, your writ for certiorari is granted. Also, here's your decision. Well, that was easy. And yes, apparently there is a dissent. Apparently there are two justices who are like, oh no, you could have read our decisions the other way. The Oklahoma Supreme Court, that's possible. They could have read it the other way. So apparently there's some justices who are like, not so much. Who dissented? Justice Leo concurs. Thank God. Justice Gorsuch dissents. My boy, Justice Gorsuch, my boy, breaking my heart. My boy is breaking my heart. Justice Gorsuch dissents. That sucks. Let's read a little bit from this dissent. Our precedent under the Anti-Terrorism and Effective Death Penalty Act establishes several rules for identifying clearly established law. We've instructed lower courts to avoid framing our precedent at too high a level of generality, to carefully distinguish holdings from dicta, and to refrain from treating reserved questions as though they've been reviewed. The 10th Circuit followed these rules. The court today does not. Instead, it summarily vacates the opinion issued below for failing to elevate to clearly established law the broadest possible interpretation of a one-sentence aside. In doing so, the court blows past Estelle versus McGuire, which months after Payne reserved the very question the court says Payne resolved. And worst of all, it redefines clearly established law to include debatable interpretations of our precedent. It is this court, and not the 10th Circuit, that has deviated from settled law. I respectfully dissent. Well, this is what I have to say to that. Yeah, I'm not buying it, ma'am. I'm not buying it, ma'am. Okay. The court errs with its recitation of the facts. Contrary to the majority's insinuations, the state presented overwhelming evidence that Andrew participated in the murder of the trial. Well, I can't speak to the truth of that issue. But that's not really the point. I don't think. Right? I don't know whether the state presented overwhelming evidence of Andrew's participation. I do know that they literally paraded around with her lingerie during closing, which seems like questionable choice. You know. In fact, the state presented an unusually strong evidentiary case. I don't even know what that means in the case of a capital murder case. I mean, I would kind of hope capital murder cases would be unusually strong, which leaves little or no doubt that Andrew is guilty of the crimes charged. Crimes charged after methodical planning. Well, super. Then you'll be able to convict her and sentence her to death with, like, you know, the evidence. Did you consider that? Did you consider that? You know, like, if the case against her is that overwhelming, maybe, you know, convict her based on evidence and stuff, like a normal trial. That could be fun. The court inaccurately portrays the state's evidence, the prosecution's closing argument, and the reasoning of the Oklahoma Court of Criminal Appeals, which once again is the Oklahoma Supreme Court, but they're bifurcated because reasons, and I don't know why, and they just are. All right, so here's what the dissent thinks is the case. Let's read the dissent's understanding of the case. Brenda Andrew married Robert Andrew. In February 2000, Rob purchased an $800,000 life insurance policy through an agent, Jim Pravitt, with Andrew as the beneficiary. She was sleeping with the insurance agent, man. That's just rough, man. The Andrews and Pravitt attended the same church. That's further rough. Pravitt and Andrew both served as Sunday school teachers. They weren't learning the right lessons, though. They weren't learning the right lessons. Pravitt apparently had some problems with some of the commandments. I seem to remember something vaguely about coveting your neighbor's wife and also not murdering. So we're not very good at our jobs, but, you know, okay. But by August 2001, they had begun an affair. The affair caused the Andrews' already strained marriage to reach the breaking point. Around late September, Andrew initiated divorce proceedings and told Rob to move out of the house. The lover was sleeping in the house? Holy shit. Well, that's what the raw temerity of this husband. The raw temerity, am I right? This husband isn't so happy that his wife's lover is living in their house. And he would really prefer they not do that. Wow, what a jerk. What a jerk. On one morning in October, Rob discovered that someone had cut the brake lines to his car. Several hours later, he received phone calls from two unknown callers, one of whom turned out to be Pravitt's adult daughter, Jana Larson, falsely claiming that Andrew was in the hospital and urgently needed him. Wow. So the brake lines have been cut, and then he gets the call saying his wife is in the hospital and he needs to drive there really, really fast. Wow. Great. Phone call records reveal that Pravitt and Andrew exchanged 82 phone calls that day and more than 50 calls the next day. The next day, Andrew told Rob she had read in the newspaper about his brake lines being cut, but no such news story existed. So the wife has what we call guilty knowledge. For those of you who want to pay attention, right? That's what they're talking about. They didn't just make it very clear. Okay. So the wife says, "Oh, I heard about your brake lines being cut." Well, how did you know the brake lines were cut? I read it about in the paper. No, you didn't. There was no newspaper article. So how did you know the brake lines were cut? Right? That's what we call guilty knowledge. She knows something she shouldn't know. Yeah, that's a problem, man. Around this time, Pravitt told Larson that Andrew had asked him to kill Rob. Pravitt later threatened to kill her if she ever threatened to reveal this information. That's super exciting. After the brake line incident, Rob sought to remove Andrew as the beneficiary of his life insurance. Explaining to another agent, he thought that Pravitt and Andrew were trying to kill him. But Andrew and Pravitt resorted to fraud to try to prevent this from happening, forging Rob's signature on a form transferring ownership of the policy to Andrew. The policy then became a serious point of contention in divorce proceedings, even though Rob was only 38 years old and healthy. They're really, really concerned about who owns this life insurance policy on this healthy 38-year-old. Why might they be so concerned about it? Hard to tell. The Andrews had 2 young children who, after their separation, continued to live with Andrew in the former family home. Rob would sometimes meet them outside the house and take them for visitation. How nice. When Rob came to pick up the children for Thanksgiving, however, Andrew asked him to come inside the garage to help him light the pilot light of a furnace. As he started to do someone pointed a 16-gauge shotgun at him from across the garage. Seeing this, Rob turned and grabbed a trash bag filled with aluminum cans, apparently in a desperate attempt to protect himself. Might work. The perpetrator shot him through the bag. Reloading the shotgun, the perpetrator or accomplice then moved within 3 feet of Rob and shot him a second time as he laid on the floor. Andrew was also shot with a .22 caliber weapon, but suffered only a superficial wound on the arm. Andrew, the wife, called 911, claiming that 2 masked men had come into the garage and attacked her and Rob. She relayed on the call that Rob was still conscious and trying to speak. By the time the emergency responders arrived, however, he was dead. During the shootings, the children were in the master bedroom watching television with the volume turned up high, unaware of what's happening. I wonder who might have suggested to them to turn up the volume on their television. I wonder who might have suggested that. Hard to tell. An ambulance then took Andrew to the hospital, where witnesses described her demeanor as unusually calm. You know, for a person who was just involved in a shooting and your husband's dead, you seem to be kind of calm about it. Police discovered substantial evidence linking Andrew and Pravitt to the murder. Rob owned a 16-gauge shotgun, well, that might be a clue, but had told friends that Andrew refused to let him take it with him when he moved out. One witness testified that 8 days before the murder, he had seen Andrew, the wife, in a rural area commonly used for target practice. The witness also later stated that he found a 16-gauge shotgun shell at the site where she was. Pravitt owned a .22 caliber handgun. Yeah, Benjamin Polch, $10, Oklahoma Supreme Court. But she's a hoe, though, motion denied. Pretty much, man, pretty much. Forensic evidence also undermined Andrew's account that she had been shot from a distance. Powder burns on her clothes and body revealed the shot had been fired within 2 inches. Well, that's exciting information. So she wasn't shot super far away with his .22 caliber round. She was shot within 2 inches with his .22 caliber round. That's kind of weird. That's a little bit weird. That's a little sus. Okay. Another witness later testified that Andrew's injury, a superficial close-range gunshot wound, was staged to make it look as though they had been the victim of attack and therefore avoid suspicion. The Andrews' neighbors were out of town that day. When they returned, they found suspicious items in their home and contacted the police. Police discovered that someone had left a 16-gauge shotgun shell and several .22 caliber bullets in the neighbor's home, both the same brand as those used in the murder. There was no evidence of a break-in, but Andrew did have a key. Yeah, that's again, the evidence against them, it's a little bit sus. The neighbors are like, we came home from vacation. There's some strange items in our home, police. We're not quite sure about this. We got some 16 gauge shotgun shells and some 22 caliber, and there's no evidence of a break-in. Our neighbor does have a key though. Prosecutors suggested after the shooting, Pravitt hid in the home until police had left the crime scene. Rather than attend her husband's funeral, Andrew traveled with Pravitt and her children to Mexico. I don't know who I need to tell this to, but apparently I need to have a discussion, because the same thing happened to Vallow with the funerals, right? And like going like to Hawaii to get married like right away and all that stuff. It's like, guys, I don't know who I need to tell this to, but if you've, been involved in the conspiracy murder to kill your husband, you might like to at least pretend that you cared for a while. Maybe missing the funeral to go to Mexico with your lover, that could potentially send the wrong kind of message to the police. I don't know who I needed to tell this pro tip to, but apparently this was something I needed to do. Maybe don't go to Mexico instead of going to the funeral. Maybe you should have gone to the funeral. Maybe that would have been a better plan. She apparently had no plans to return. Before the trip, Andrew tried to transfer funds from her account to Larson so Larson could wire the money to her in private. The pair also asked Larson to help them forge Rob's signature on a document granting Andrew permission to take the children abroad. Holy shit. Andrew abandoned her car in an apartment complex before leaving. She also stopped making payments on her home. Private researched traveling to Argentina after hearing Argentina did not extradite. Nice. Larson, however, cooperated with the FBI and refused to wire Private or Andrew any money, despite their repeated requests. When they ran out of money 3 months later, they returned to the United States and were immediately arrested. While in Mexico, this has got to be good. While in Mexico, Private wrote a letter addressed to Andrew's daughter, claiming that he and an unnamed friend had killed Rob, and Andrew had nothing to do with it. He stated he did so because Andrew had told him 4 days before the murder she planned to beg Rob to take her back after Thanksgiving. This was a peculiar claim, given that hours before the murder, Private had moved his washer and dryer into her home. Yeah, that doesn't really flow. Okay, the reason I did it has nothing to do with the wife. It's nothing to do with the wife. It's because she was about to take him back. Really, you knew that she was about to take him back. Yeah. And so like hours before the murder, with this knowledge, you decided to move your washer and dryer into the home. It's almost like you had knowledge that Rob wouldn't be around for very long. Yeah. And far from adopting a conciliatory attitude towards Rob, the night before the murder, Andrew called a friend just to say, I hate him, I hate him, I hate him. The friend recalled that comment, made the hair stand up on the neck. She hated that man. Okay, so she might have done it, guys. She might have done it, but once again, just like convict her at a trial with like evidence and stuff. Just do the Oklahoma prosecutors need help? Did they forget how to do a trial? I could help if that's the problem. See, what you're going to want to do is you're going to want to present evidence that links them to, the murder. You can do this through the use of fact witnesses who like saw stuff. You might also consider using evidentiary records like banking records and the forged documents, and maybe get yourself a signature expert to confirm it was forged, and people who heard the statements and stuff like that. And maybe you could like call those people to the stand and ask them questions and stuff about the things they saw, heard, the documents and so forth and so on. And then, you know, you could convict them and stuff. Do you need help? I'm available. A jury convicted Andrew of capital murder and she was sentenced to death. So too was Prevett in a separate trial. Sex and marriage were unavoidable in Andrew's trial. Perhaps to some degree they were. As it relates to the affair with Prevett, yeah, I mean, to some degree, some of that's probably appropriate, but I'm not so sure about her cheating on other boyfriends or other things that happened years before. So, you know, maybe like, you know, keep it to the facts of the case would be really helpful. And the state introduced a variety of evidence about sexual behavior. On direct appeal, Andrew challenged some of the sex-based evidence introduced during the guilt phase, arguing it was irrelevant and unduly prejudicial. Given that this trial was primarily about the motive and intent of Andrew to kill her husband with the aid of Prevett, the Oklahoma Supreme Court held that much of the evidence, particularly concerning her relation with Prevett, was not just admissible, but highly relevant and probative. But not all of it was so. The Supreme Court of Oklahoma recognized that some of the evidence, like the sort of outfits Andrew wore to dinner outings, was not relevant. Yeah. Given the overwhelming evidence in this case, however, has determined the introduction of the irrelevant evidence was harmless. The court suggests that the Supreme Court of Oklahoma permitted the evidence of Andrew's 2 prior affairs simply because it showed she had a penchant for adultery. In reality, the Supreme Court of Oklahoma concluded this evidence helped to prove motive and intent. How? How do her prior affairs relate to her motive or intent for the murder? I don't know. She wasn't very good at being a wife, apparently. But, you know, she also wasn't very good as a Sunday school teacher. She apparently lost control of several commandments. That there's the adultery, there's the coveting one, there's the murder one, there's bearing false witness with the forgeries. We're not doing really good on our 10 commandments punch card. Love thy neighbor isn't looking real solid right about now. Yeah. Andrew had shared with both these men her hatred for Rob Andrew and his wish that she were dead. Evidence that Andrew had a close personal relationship with these men gave credence to their testimony. She had revealed to them intimate details of their marriage. The court also insinuates there was something improper about the state's introduction of evidence on Andrew's failings as a mother, but the continuously omits the context. Andrew asserted she was a good mother as part of her defense in both the guilt and penalty phase of trial. In presenting evidence to the contrary, the state was simply rebutting a point to which Andrew had placed an issue as clearly entitled to do. During closing arguments, the prosecution did not rely on any of the sexual evidence that the Supreme Court rarely find irrelevant. The prosecutor's reference to the underwear Andrew brought to Mexico is no exception. The Supreme Court of Oklahoma recognized the evidence bore on Prevett and Andrew's intentions in fleeing to Mexico, a key interest in the case. Finally, this court is wrong to imply the prosecution drew any kind of contrast between Rob and Andrew in terms of religious commitment. The prosecution mentioned Rob's religious faith to emphasize the world lost a fine human being when Rob was brutally murdered. Rob seems to have gotten very much the short end of this stick. Rob seems like he got very much the short end of the stick. And if the woman did all the things that they say she did, then execute her. I have no problem with that. Execute her. But, you know, maybe less with the super duper prejudicial evidence, which incidentally, by the way, no one has determined as of yet that it's so prejudicial it requires a new trial, because literally no one has determined the issue. Right? We were trying to debate whether it was even possible, which apparently we need the Supreme Court to clarify. Is it even possible that it could be so prejudicial? And now we actually have to determine whether or not it was. There we go. Okay, good luck. Good luck. The prosecution never cast any sort of religious judgments against Rue. Tellingly, the court is unable to cite even one example of prosecutions condemning Andrew in religious terms. The record makes it clear it was the defense, not prosecution, that repeatedly appealed to the jury's religious sentiments at sentencing. For example, the defense called a pastor as a witness, who testified about the importance of mercy as a biblical value. And in closing, the defense repeatedly quoted the Bible that said if Rob could speak to the jury, he would ask them to forgive Andrew. I don't know, man. I don't know. You want to say the guy that was murdered would ask for mercy for the murderer? I don't know, man. That strikes me as a lot of chutzpah, but okay. The prosecution simply asked the jury during rebuttal to ignore defense's attempts to guilt trip them. Holy shit. The court's legal analysis fails no better. Under the Effective Death Penalty Act, Andrew may obtain federal habeas relief only if the resolution of the due process claim was contrary to or involved an unreasonable application of clearly established federal law as determined by the holding of this court. The standard is and was meant to be difficult to meet. It forecloses relief unless all fair-minded jurists would agree the Oka's decision qualifies with his court presence. I don't want to call them Supreme Court anymore. I don't want to call them Supreme Court because they're not worthy of the name. I'm just going to call them Oka now because they're a joke. Lol. Oka needs help. This court today asserts that the due process clause forbids the admission of evidence so unduly prejudicial as to render the defendant's trial fundamentally unfair, and holds the 10th Circuit erred in failing to recognize this rule as clearly established. In holding so, the court commits the error of framing our precedent at too high a level of generality. And even setting that aside, the reading of precedent is one in which fair-minded jurists could easily and justifiably disagree. Holdings that speak only for a high level of generality cannot supply a ground for relief. We've repeatedly cautioned lower courts against framing our precedent too generally. We've instead required courts to ask whether our precedent establishes clearly the specific rule. The 10th Circuit heeded our repeated warnings. The majority disregards them. Payne held that the 8th, I don't really like this analysis very much because it's just like, it's not really getting to the core of the issue, to my mind. It's like Gorsuch and Thomas are debating whether or not the 10th Circuit correctly interpreted the Supreme Court. And it feels slightly off point to me because, just what is the law? Right? I mean, just what is the law? It's like asking whether the 10th Circuit correctly interpreted the Supreme Court, but we're at the Supreme Court. So can't we just say what the law is? I don't know. It just feels like slightly we're asking the wrong question. The 10th Circuit correctly rejected Andrew's claim that Payne's caveat clearly established the admission of any evidence so prejudicial as to render the trial fundamentally unfair would violate due process. It held that Payne's brief discussion of due process only applied to scenarios in which the victim impact statements are unfairly prejudicial. Well, no, but that's okay. Nevertheless, the court vacates the 10th Circuit decision, marking for the first time it's ever summarily set aside a lower court's decision for failing to find a legal rule as clearly established. I mean, to be fair to the dissent, the summary nature of this decision is one hell of a bitch slap by the Supreme Court. The 10th Circuit's going to feel that one, right? I don't know off the top of my head when the last time the Supreme Court did a merits decision without oral argument. They'll do it on what's called the shadow docket relating to injunctions, for example. But I don't know when the last time the Supreme Court has done a merits decision without oral argument. So the Supreme Court bench slapped the 10th Circuit pretty fucking hard. So they're going to definitely feel that one, man. That is a big fuck up. That is a big fuck you. Yet the court does not identify a specific on-point holding from Payne or any other decision the 10th Circuit overlooked. Instead, it faults the 10th Circuit for failing to distill a general legal principle about fairness from Payne's one-sentence due process caveat. In the process, the court does not once mention, less distinguish, or in many precedents admonishing the lower courts not to define clearly established law too abstractly. Incidentally, we got to talk about clearly established sometime, because I don't really like this language where I don't like the impact of it as it relates to, you say clearly established, and all I can think of is qualified immunity. And it's like, I think, we need to do something else, guys. We need to do something else. This isn't working for me. This specificity requirement serves as an important function. Defining clearly established law as overly high-level generality makes it virtually impossible to find an unreasonable application relief warning. It is not a reasonable application of more general rule for state court to decline to apply a specific legal rule that's not been squarely established by this court. If a habeas court must extend a rationale before it can apply to the facts at hand, then by definition, the rationale was not clearly established at the time of the state's court's decision. When a legal rule is defined too high of level of generality, it becomes impossible to apply to the facts without articulating subsidiary legal principles that are not themselves clearly established, leaving no principal basis for granting relief. To the extent some courts nonetheless grant relief based on an overly general principle, they defy the ADAPA. As we've explained, when courts use a high-level generality to transform even the most imaginative extensions of a case law into clearly established law, they wrongfully perform an error under the guise of the applicability of the law. Thus, at best, today's decision will simply create an extra, unnecessary step judges must perform before they can deny a habeas claim that's due to fail. At worst, it will confuse lower courts into misapplying the standard of review. I wonder if, it's possible for this to be, remanded all the way back to the state court. Maybe give them another shot at it. I don't know if that's possible or not. But it feels like maybe we should give the state another shot at this. Oh, Lord. Consider Andrew's case on remand at the 10th Circuit. I mean, it doesn't really make sense because we're applying federal law, so probably not. But, it just feels like, maybe we could try not to fuck it up so hard next time if we give you another shot at it. Oh, Lord. Consider Andrew's case. On remand, if the 10th Circuit properly applies ADEPA, it will still find the state court reasonably applied the principle the court has identified no matter what it thinks of the specific acts of Andrew. Well, maybe. I don't know. I haven't done the analysis all the way through. I don't know. I don't know whether or not this is such a problem that it requires us to set aside the verdict. I don't know. I haven't done the complete analysis. But I knew it was possible. But apparently Oklahoma and the lower federal courts are just now figuring that out. So now they actually have to think about it. The horror. They have to figure out whether or not there's a problem that requires us to do something about it because it's a due process problem. The horror. I know. The absolute horror. They might have to think. Andrews challenges the admission of evidence from her guilt phase, as well as the non-victim impact evidence from her penalty phase. It's not uncommon for the constitutional rule to apply somewhat differently at the penalty phase as guilt phase. Well, no shit, I knew that. And any fair-minded jurist could believe that victim impact evidence raises unique due process concerns. Otherwise, the specific question of whether victim impact statement categorically violates the Eighth Amendment would never have arisen. So it'd be impossible for the 10th Circuit to grant Andrew relief without impermissibly extending Payne's rationale. Yeah, but the question is whether or not it happened here. You don't have to extend the rationale. You just have to determine whether or not it happened here. You can do it. I believe in you. Andrews' claim also cannot survive on remand because Payne's long sentence on due process does not establish a test for determining whether a trial is so infected by prejudicial evidence as to be fundamentally unfair. I mean, you're right, it doesn't, but, you know, there's examples in the case law. So you're right, there's no exact test. You're correct. I'm not aware of a test, right? We don't know, or I can't tell you whether or not something is so bad as to be fundamentally unfair. I don't know. We're in a bit of I know it when I see it territory, although it's not quite that bad because I can look to examples from the case law and be like, well, here's some situations in which it was determined. Here's some situations in which it wasn't determined. Which of these categories is this thing more like? Wow. You see what I'm doing there? I'm using things from the past to like pattern match and stuff. Wow. I know. It's amazing, right? Like, here's a whole bunch of cases in which it was deemed to be a due process violation. Okay. Here's a whole bunch of cases in which it was not deemed to be a due process violation. Okay. Here's this case. Is it more like category A or category B? Category A or category B? Which of these things is it more like? Once again, you might have to think the horror. The horror. It might require thinking parts. Wow. It does not identify what factors a court should consider, how to weigh them, or what the gap is, say, between an evidentiary garden variety rule 403 error and a fundamentally unfair trial. You're right. I think we could try to figure it out, though. I think it'll be fine. To consider the specific facts of Andrew's trial, the 10th Circuit would need to decide those matters for itself. But then it would be, by definition, doing more than applying clearly established law. No, it wouldn't. It would be applying the facts to the clearly established law. No, it wouldn't. It would just be applying. No. It would just be applying the facts to the clearly established law. In this case, the clearly established law is a bit vague. But that doesn't prevent it from being clearly established. Right? The rule is a bit vague, but it's still clear. It's clearly vague. Right? We know what it is. Even if it requires you to use your thinking parts. Even if it's put the stuff in column A, put the stuff in column B, is this thing more like column A or column B? I mean, that's clear, but you might have to think about it. I would like to have a professorship too. I actually applied for one recently. I don't expect to hear back, but I did apply for a position in Wisconsin, which means if I got the job, I'd have to go where the snow lives, which is pretty scary, incidentally. I don't know, but maybe. In an effort to show that remand will not be futile, the court observes that clearly established law can apply to new factual permutations. This is true so long as one keeps in mind White's admonition that ADEPA does not require states court to extend our precedent to any arguable distinct context as would be necessary to require relief. This court attempts to escape White's strict liability by invoking Taylor versus Rojas, or to suggest a general constitutional rule can be a basis for relief in an obvious case. But then the majority admits that Taylor is qualified immunity decision, rendering it utterly inopposite. Although both qualified immunity and ADEPA impose demanding standards based on clearly established law, the two are meaningfully different. A plaintiff overcomes qualified immunity by undermining case law, finding a constitutional violation under similar circumstances, except that in an obvious case, a body of relevant case law is not needed. In Taylor, this court found the obviousness exception applied. ADEPA, by contrast, permits relief only when a state court decision undeniably conflicts with this court precedent. Regardless of what we think about the merits of due process principle that Andrew asserts, it does not warrant relief under ADEPA, absent a prior Supreme Court holding the principle applies to circumstances presented in this case. There's no such holding here, and the 10th Circuit was right to insist on this one. I wonder if Justice Gorsuch, by any chance, is writing this because it's the 10th Circuit. I wonder if he feels a little bit of fealty to his former colleagues. I mean, I don't know, but maybe he's writing this because it's the 10th Circuit, and he feels like his friends are being dissed. I don't know. Even setting aside the level of generality problem, the court is wrong to find a clearly established rule of law. For at least three reasons, a fair-minded jurist could disagree with the court's reading of Payne. The court holding otherwise only reaffirms the clearly established law to include debatable interpretations of our precedent. First, a fair-minded jurist could conclude that Payne's lone sentence on due process is not a holding at all. Although Payne asserted that a victim impact statement could violate due process if it was unduly prejudicial, the court found that in this case, the evidence serves entirely legitimate purposes and so declined to disturb the capital sentence under review. The court's statement that difference case presenting different facts could violate due process was not dicta because it is not necessary to the disposition of this case. But it was case specific, which implies that in other cases, the opposite, right? Yeah. I feel like I could be a professor. I feel like I'm a professor. And I have to tell you the truth, guys, and I don't know how much hubris it is on my part, but, you know, I've seen some of the teachings from some of the professorship out there. And I have to tell you guys, you know, I mean, I'm not necessarily saying I'm the best professor there's ever been, but I'm definitely not the worst. I've seen some professors out there and I'm like, yeah, I don't know, man. I don't know. I said, yeah, I think I'll be fine. I think I'll be fine. Lord. The court insists that, and I'm definitely better than every CLE ever, continuing legal education. Plus, I have experience explaining the law to lots of people, including through tele apps. So, I think I'd be a fine professor. I think I'd be a fine professor. Oh, Lord. Hardly the only reasonable interpretation of Payne, which nowhere sets forth a reasonable interpretation of this clause. If you are faculty at a law school or have a friend that is, please feel free to refer me. I'm available. If you or someone you know is faculty at a university, do you happen to know your provost? Are you a provost? Give me a call. Trump just declassified JFK, RFK, and MLK docs. I'll tell you what, I'll look at that as soon as we're done with this, okay? And give me a second, and I'll look at what we'll do it at the end of the stream. Just give me a second. We're on page 25 of 29. Give me a moment. We might do it in a separate stream because it's big news, but just give me a moment. We might take a short break so I can get some water, but you guys will be fine. We'll do the MLK thing soon, I promise, all right? I'll do the MLK thing if you guys get me a professorship. Yeah, I'm no longer begging for super chats. If you get me a professorship, we'll do the MLK thing. Let's see. The court's interpretation makes sense only if we assume the Payne court was seriously considered holding victim impact evidence categorically unconstitutional despite it serving entirely legitimate purposes in the majority of cases. What is a professorship? A position a professor holds? What is a professorship? A position a professor holds? Professorship is a word, right? I'm not just making that shit up, right? Yeah, professorship. Noun, the office or position of a college or university professor. Yeah, it's like, yeah, I was using the word correctly. Why are you giving me a hard time? Why are you giving me a hard time? You're in the paralegal program? Yeah, maybe I'll do something like that. Talk to your faculty and, press on. This is hardly the only reasonable interpretation of Payne, which nowhere sets forth the reasoning of the court ascribed to it. The court's interpretation makes sense only if we assume that the Payne court was seriously considered holding victim impact category unconstitutional despite serving entirely legitimate purpose in the majority of the cases. That would be a highly unusual approach to constitutional litigation. Another reasonable interpretation, indeed a far more plausible one, is the court simply wanted to make clear that its rejection of a categorical rule against victim impact statement does not rule out future fact-specific challenges. Well, I mean, no shit. That's obviously implied. That kind of dicta in common cases rejecting categorical challenges. Thank you, JM King 2008, for becoming an uncivilian. If we were to treat Payne's sentence about due process as a holding, a fair-minded jurist need not read it as broadly as the court does. General expressions in every opinion are to be taken in connection with the case which those expressions are used. If they go beyond the case, they ought not to control the judgment in a subsequent suit. This principle applies with special force when a party claims a single sentence in an opinion establishes a lone principle. A fair-minded jurist could believe that the scope of any holding established by Payne's cursory discussion of due process is limited to Payne's analysis. On the majority telling, Payne limited a categorical Eighth Amendment prohibition on victim impact statement because of the available alternative of due process protection against such evidence. Because Payne was not considering the role of due process vis-a-vis any other kind of evidence, but why wouldn't it? Why wouldn't all evidence be subject to the same rule? That doesn't make sense. A fair-minded jurist, when it comes to the constitutional impact, obviously, why wouldn't all evidence be subject to the same constitutional rule? Why wouldn't and of all the constitutional provisions, wouldn't due process be implied in all evidence? How could evidence not be subject to due process? Because in order for the jury to consider the evidence, it has to be presented, right? And in order to present it, you have to go through a procedure to present it, which therefore means there's due process, right? So how could you not have due process implied by all evidence? I don't know. Yeah. Finally, a fair-minded jurist could rely on the court's later decision in Estelle to conclude that Payne did not establish any general due process prohibition on the applicability of the process. The court in Estelle granted habeas relief on the ground that admission of irrelevant and prejudicial prior act bad evidence that helped render the prisoners fundamentally unfair in violation of due process. This court reversed, holding the evidence in question was relevant to an issue in the case. Having reached that conclusion, the court added that we need not explore further the apparent assumption of the Court of Appeals as a violation of due process guaranteed by the 14th Amendment. I'm tired of reading this decision. I don't want to read this decision anymore. I just disagree with the dissent. I'm bailing out of this decision. We read the majority. I read most of the dissent. It's not getting any better. I'll read the very end conclusion, though, because this part is true. Summary vacator is rare. It is fucking rare. This court has traditionally reserved it for uncommon situations in which the law is stable and settled. Today, however, the court turns this approach on its head, steamrolling to set aside the entire Seventh Circuit's decision. Yeah, okay, fine. Justice Gorsuch, that's fine. All right, let's take a look and see what Trump did. Did you guys know Trump is president now? I don't think some people know that yet. It seems that some people are confused about that point. On another related note, did you know that the song Hail to the Chief has lyrics? I didn't know that until like yesterday or the day before. I didn't know the song Hail to the Chief had lyrics. Did you know the song Hail to the Chief had lyrics? Hail to the chief we have chosen for the nation. Hail to the chief, we salute him one and all. Hail to the chief as we pledge cooperation in proud fulfillment of a great noble call. Yours is the aim to make this grand country grander. This you will do, that's our strong, firm belief. Hail to the one we've selected as commander. Hail to the president. Hail to the chief. Oh, shit. So fucking lame. So lame. God damn it. The lyrics are lame as shit. All right, let's see what we got. Well, there's nothing on the White House website yet. Apparently, we've recognized a new tribe. That's exciting. So the federal government has recognized the Lumbee tribe of North Carolina. So if you're a member of the Lumbee tribe, congratulations. The federal government says you exist. I don't see anything on the FBI thing. Trump, JFK. Trump signs order. Well, it'd be nice if I got a copy of that order. That'd be nice. So we may have to wait for, the order. How does the news know these things? I guess they literally saw him do it. But it's not available on the White House website yet. Although they've been pretty good about putting things up there pretty quick. He signed an EO? I'm sure he did. But I'd like to, read the EO. No EO. No EO for me. No EO for me. Lame. Maybe it's on Twitter. Twitter sometimes gets to it faster. It was removed from the website? Excuse me. It's happened apparently 4 months ago, so I'm not surprised it's not available yet. Okay, here we go. I've got page 1. Page 1 is less helpful to me than other pages. I would like other pages, please. I'm getting teased by page 1. Yep, not yet. I guess we'll probably do it in an hour or something when the thing is available. Yeah, it'll be available, I'm sure, in short order. Yeah, all right. I guess we'll end the stream for now. And we'll pick it up whenever the thing's available. So let's say roughly a half hour, maybe an hour. We'll do a stream. I'll see you guys in a minute, okay? Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.